Hello, I'm Judge Brendan Murphy, Chief Magistrate of Cobb County. You're here for your first appearance hearing. During this first part of the hearing, I'll explain some of your constitutional rights and the procedures that will be followed in your case. You have the right to remain silent. Any statement you make may be used against you. You have the right to the presence and advice of an attorney, either retained or appointed. If you can't afford to hire an attorney, the circuit defender will appoint an attorney to represent you. In order to determine whether you qualify for an appointed attorney, the circuit defender may interview you, require a written application, or ask you to provide additional supporting documentation about your income and household. Please make sure you comply in a timely manner so that an attorney can be appointed for you as soon as possible. In felony cases, you have the right to a grand jury indictment, though in some circumstances, a prosecutor may directly accuse the case. In the Cobb Judicial Circuit, the grand jury meets on most Thursdays to consider indictments. Note, however, that by law, neither you nor your attorney may attend the grand jury proceedings, with very limited exceptions. For misdemeanor charges, including traffic offenses, the prosecutor may accuse your case, or you may be tried on a uniform citation. Regardless of how your case is charged, you have the right to trial by jury. Before receiving a bond, you have the right to a commitment hearing. In Cobb County, this hearing is typically called a probable cause or PC hearing. At that hearing, which would be held on a future date, the prosecutor will present some initial evidence, typically the testimony of a law enforcement officer, and you, or more commonly, your attorney, would be able to ask questions and present evidence. Then, the judge will decide whether there's enough probable cause to bind your case over for further proceedings. The second part of your first appearance hearing will begin shortly. You will each be brought before a magistrate judge. The judge will formally inform you of the charges pending against you. If you don't want the charges read out loud, just ask the judge. If you have any questions about your constitutional rights, ask the judge. If you want an attorney appointed to represent you and you don't know what to do, ask the judge. Further, the judge may set or modify your bond. However, for certain alleged offenses, such as violations of probation, bench warrants, or failures to appear, the judge will not set a bond. For offenses that are bailable only before a superior court judge, the judge will inform you of a future hearing date and time when another judge will consider whether to set a bond. If you are arrested without a warrant and one hasn't been issued yet, the judge will also make a fair and reliable determination about the probable cause for your arrest. However, today is not your trial, and you always have the right to remain silent. I'm also required to tell you that if you wish to plead guilty, let the judge or deputy know. However, no guilty pleas will be taken today. And remember, it's always a good idea to speak with an attorney that represents you before making any decisions about waiving your rights and entering a final plea. Finally, the magistrate judge may ask for your true name, date of birth, educational level, ability to read and write the English language, or other questions to make sure you understand these proceedings. The rest of your first appearance hearing is set to begin shortly. Good luck to you.